Hello everyone, welcome to Cashcroft TV. My name is Kaylin Ashcroft. Thank you very much for watching this video here on Guide to Legal History and Historians, where we will be covering all of the chapters and respective authors of the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tallmans. This episode will be covering chapters 41 and 42. However, these do not need to be watched in order because neither the textbook is designed or structured in a way that must be read in this order. So in this specific chapter, we will be covering Chinese law and Aboriginal Indigenous law by Tahirih V. Lee and Shaunnagh Dorsett, respectively. So in the style of Plutarch's Lives as well, we will have biographies of both respective authors, and in the end we'll also have a comparison where hopefully we can learn a little bit more about these two scholars and their respective works. So without further ado, we will begin with Tahirih V. Lee and her chapter. So this chapter is in Traditions, section 4 of the Oxford Handbook of Legal History, titled Traditions, Tracing Legal History, and her chapter is titled 41, or number 41, By the Light of the Moon, Looking for China's Rich Legal Tradition. And the author's name is Tahirih V. Lee. In terms of a brief biography about her, she is the Associate Professor at Florida State College of Law. She has a Bachelor's in History from Stanford University, a Master's in East Asian Studies from Stanford University as well, a Master's in History from Yale, a Master's of Philosophy or MPhil in History also at Yale, a Juris Doctor at Yale Law School, and as well a PhD at Yale in History at Yale University. She is a leading scholar of Chinese law and legal history. Her doctoral dissertation was titled Law and Local Autonomy at the International Mixed Court of Shanghai. She currently teaches courses in Chinese law, international business transactions, comparative law, civil procedure, and international trade transactions, which is a course developed with the Shanghai University of International Business and Economics and with funding from the Shanghai Municipal Government. She links in this her works, she links American and Chinese students in simulated commodity trades. So it's interesting to note that she also has funding through China as well, so at least some sort of support on both sides of the Pacific Ocean, I suppose. She previously taught at the University of Minnesota Law School, Notre Dame Law School, and Loyola University of Chicago School of Law as the Wing Tat Lee Chair in International and Comparative Law. She also held positions as the Pew Scholar at the Harvard Academy for International and Area Studies, and she was an associate at the Harvard Fairbanks Center for East Asian Research. She also chaired communities of the Association of American Law Schools and the American Society of Legal History. Her publications include The Application of Law as a Key to Understanding Judicial Independence, published by the Florida International University Law Review in 2022, and as well Updating Legal Education with Chinese Import, Technology-Based Experiential Learning, published in the Legal Journal of Legal Education in 2014. And she also has a 4-volume anthology titled Chinese Law, Sociological, Political, Historical, and Economic Perspectives, published by Garland Press in 1997. So much significant publications, which I endeavor to, and I suggest, and I hope you might be interested in as well. So without further ado, her chapter specifically in the Oxford Handbook of Legal History is in section 4, titled Traditions, Tracing Legal History, one of my favorite sections so far in the textbook, as it sort of has these kind of breaks down different histories based on different geographies within the world. And her chapter is titled By the Light of the Moon, Looking for China's Rich Legal Tradition, which essentially I've shortened because hers is basically the encompassing chapter of Chinese legal history. So without further ado, we'll start with the introduction. So she opens up the chapter firstly by noting her position at the time, which is the Associate Professor of Law at the Florida State University, as mentioned. And the author also stated that she thanks William Elford, Nancy Park, Mary Sato, Chang Weizhen and Margaret Wu for their encouragement, instruction, and inspiration at crucial moments in producing this chapter. So, nice gratitude on her part. So she opens up with, the field of Chinese legal history is beset by nearly insuperable obstacles. How to decode ancient and pre-modern texts, when even texts until the 1940s used a literary language that differed from spoken Chinese. So there's this, firstly, at the very inception, a textual difficulties. How to access primary sources when they are locked away in rooms that are barred not just to non-Chinese scholars, but also to scholars as well. So currently there are political, we call, or even physical barriers preventing Chinese and non-Chinese from accessing these, and how to recognize law when China's government, intelligentsia, and its wider population have debated the law's very definition and utility. So there's even scrutiny within and without China. The old Chinese saying, which gives the title of her brilliant chapter, it evokes this widespread cynicism about even the existence of rule of law in China, in that Chinese law is like the light of the moon. It is different at the beginning of the month than in the middle of the month. In other words, it is constantly changing, suggesting law means whatever the ruler is content to present and say it means. Additionally, this metaphor can be expanded as well, as she points out, as a metaphor of less ideal conditions Chinese legal historians operated in that the moon presents a secondary light. It reflects off the sun. So firstly, it's changing, and secondly, it's secondary as well. And therefore, it's illuminating the landscape imperfectly. So she notes history is challenging, and we do not yet know whether the rule of law that bound the lawmaker and served the public ever took hold in China. So that's an ongoing debate, and as we'll see, it sort of has fluctuated throughout time. Nor do we know the extent to which substantive law reached the population at large and affected the lives of those of the world's most populous society. Nor do we understand fully the sources of authority of the law and its officers and the level of respect for them held by the population. So was there uprisings? Were there many uprisings over time, or just disobedience? Many over time, few over time. Regional variations in legal landscapes stretched over nearly 4 million square miles have not yet come into view. So China is also geographically massive country, so maybe things varied over time, but also varied across space as well. Taiwanese Tung Tso Chu, a European born and raised in China, scholar, as well as Sibyl van der Spekkel, have used broad swath of contemporary legal digests from the Qing period, from 1644 to 1911, showing the limitations of runners, which is a translated term for staff used by the magistrate who delivered and enforced orders, who notoriously exacted bribes from the local population. So these two scholars have pointed out that as things moved away from the capital, these runners would often take bribes and sort of misinterpret law as well. The Qing often is seen as the culmination of previous works, so like these two scholars, many do focus on the Qing period because it's seen as kind of coming later, so it culminates previous law. But that is probably, in my opinion, and I believe the author would also agree, not always necessarily true, but it does. We cannot neglect earlier periods, even though it might be convenient to do so. Chang Chen Fu Mei and John Watt each wrote significant studies on the work of the Qing district magistrates, as well. And they noted the government was fully aware of the consequences of the clerks' corruption. So these two also, by looking at the Qing dynasty, also noted corruption through the clerks, and even recognized the central government was aware of this clerks' corruption. The Dutch linguist Anthony Hulsu was a rare exception, produced a much referenced work on the Han dynasty, which lasted from 206 BC to AD 220, and noted law as well as the Qin dynasty, which is 221 to 206 BC, not to be mixed with Qing dynasty, and the Tang dynasty as well, from AD 618 to 907. So three huge periods, basically going from 206 BC to 907 AD. His rival in Germany, Karl Bucker, focused on the Tang dynasty, and Kung Chuan's Heso attempted to sweep over thousands of years, but led to broad generalizations. Like the system constructed by Shang Yang was extremely uniform because it was based on definite meanings of words. So some of these, she notes, if they try to grasp too large swaths of time, they come to overgeneralizations, such as because there were definite meanings in the words, it was extremely uniform. That's probably not always true. There are some words over time that have changed in definition, and some words do inherently, when forever will exist, have ambiguity. She also looks at the works of Paul Rechnevsky's Zi Yun Ching which, my apologies for the pronunciation, which showed the Mongolian customary law introduced in dynastic codes of China in 1291 AD, and Jiang Yonglin and William Jones' translation Da Ming Lu and Da King Lu Li may have overemphasized dynastic code significance. So one of these scholars notes that there were outside influences, such as the Mongolians influencing Chinese law, and the other that perhaps the dynastic codes, which other scholars have focused primarily on, may have an overemphasized significance. Further, the work of Brian McKnight and James Liu contributed to the translation of judgments from the Song dynasty, which lasted from 960 to 1279 AD, so we're starting to see you can build a full picture, but you'll have to combine the works of many different scholars, or if you do find one scholar, it might be a little overgeneralized in some cases. Nonetheless, all attempted to support the appreciation for sophistication of experience of law over lengthy and an unbroken span of time. Note, these unbroken spans of times are still broken up into different dynasties, however. This has led the author to question the methodology and approach, and she therefore presents 3 questions for now and the near future. 1. Historians, scholars, and anthropologists with their different training and bases of knowledge ask different questions. The author would like to explore how these 3 approaches have shaped the field to offer a potential for contributions to come, and therefore she also presents that there's merit in all 3 approaches. 2. Comparative law inextricably intertwines with Chinese legal history, and its use and abuse needs to be examined and lessons learned, and therefore there need to be proper processes set in place. And 3. Given the sophistication for the centuries of Chinese rulers' efforts to propagate official lines about the rule, it is exceedingly difficult for scholars to piece through to see what's actually happening. And to succeed better will take something like a law and society approach, as we discussed in the previous law and society chapters, or law _ society, because it could be law or society, law with society, law and, or society and law, nevertheless, and that nevertheless it's a bottom-up approach as opposed to political law and politics, which would be a top-down approach, where law's distinctiveness from society is treated most as a myth and more as a myth than a reality, and this may help in this endeavor. So these 3 things will make sense, but these are the common themes to which hopefully lenses to look through this chapter as we progress. So that is the introduction. Moving to section 1, methodological balance, historians, lawyers, and anthropologists. So these are the 3 different trainings and bases of knowledge is referenced. So the author, Tahirih V. Lee, notes, for the last 2 centuries, Chinese legal history has begun to reap the benefits of archival work in China and Taiwan. There's been outstanding research, he notes, by history departments in American, Chinese, and European universities. However, for the most part, these scholars have lacked law degrees. It may be no coincidence that these studies have tended to use court cases as lenses onto Chinese society rather than China's legal system itself. So perhaps non-lawyers might focus on court cases specifically, thinking they might be doing the right thing, but rather the lawyer framework as she presents would be to look at the legal system itself. For example, historians Zhu Jiukun, Feng Xiaoting, Man Ban Quan, Mark Ali, and Thomas Bouillot each separately gathered and analyzed thousands of court records, but principal conclusions revolved around trends in demography, population density, commercial practices, and violence. And only secondarily do they trace the developments in law or in juridical treatments of disputes. So sort of one of the lacking points, first lacking point is that a lot of these scholars are not lawyers and therefore have taken a micro-focus on these court records. Furthermore, for example, Bury describes the efforts of Yongzheng Emperor, possibly the Qing dynasty's most powerful ruler, who lived from 1734 to 1756, or ruled from 1734 to 1756, as evidence of changes in society in their time, but leaves aside the possibility that the legal mechanism was simply poison to the Chinese society, and that it was faulty law that needed correction in order to stem in its ill effects. So the non-lawyers supposedly have hypothesized that law changed as a result of the underlying social currents, but perhaps the law itself was faulty and therefore inevitably had to be corrected. So just a sort of different way, kind of, you can take the law and society approach and that law reflects society, or just a strictly lawyer approach in that it's the law inherently was faulty in itself and therefore would have, in any geography, would have needed to have been changed. And therefore weaknesses in laws or in legal mechanisms are well known to scholars with legal training, she notes, and perhaps mainly because they have run across many of them. So they would see that the law itself had a problem and it wasn't necessarily a big change by this leading ruler or changes in the underlying society. Bradley Reed, too, dug up significant material on staff employed by district magistrates in Sichuan province during the Qing period, and refuses to dichotomize states and society, which would relegate the magistrates' staffs on one side or the other, but instead sees China as full of nests of socially differentiated institutions, practices, and resources. And he comes from they come from political science, so such as in Samuel Huntington and Joseph Nye, who's Joseph Nye specifically is one of my favorite authors at Harvard University. I read many of his great books and actually had a small email correspondence with him, and he's a very helpful individual. Not saying to just send him emails, he's very busy. Still, such exhaustive studies cannot assume clerks and runners to be permanently rehabilitated, especially during the opioid crisis, must be noted too. So even taking a fully legal approach or a social approach, note that perhaps there's even the technical approach that a lot were addicted to opioids at the time, which obviously skewed a lot of their functions and thought processes. Therefore, dysfunctions required these top-down approaches to often top-down approaches to kind of contain these people, and still some need of state and society dichotomization, therefore some sort of legal process. So nonetheless, this to counter Bradley Reed's approach, where there was no separation between law and society there, or the state and people, there kind of has to be, especially during as evidence in periods of the opioid crisis, for example. The author then notes that law schools in the U.S. could produce more Chinese legal history scholars, including those who also have PhDs in Chinese history, for course correction. So these historians should also have law degrees, as she herself has, PhD and a Juris Doctor, and as I think not a rule of thumb, but most of the scholars in the Oxford Handbook of Legal History do have a PhD in history and a Juris Doctor, or the equivalent law degree. However, some have only a Juris Doctor, some have only a PhD, so it's not sufficient, one might say. But the era of diminishing, but she notes in the era of diminishing budgets, likely to continue to marginalize both legal history and Asian law. So there's diminishing budgets. The author notes that might diminish both legal history and Asian law. And China's own archives, newly opened in the 1800s to scholars as part of the Gaiji Keifeng policy under Deng Xiaoping, are more closed now than more 20 years ago. So firstly, there's decreased budgets, but also things seem to be more closed in this nation. And may this trend reverse as well, she hopes. Anthropology, like Rebecca French, have also conducted fieldwork on courts and dispute resolution in Tibet, may also broaden the official line about law, so also incorporating this anthropological point of view. into local custom and the daily realms of norms and values and other sources of the authority of the law. In contrast to Anglo-American common law lawyers and judges, Tibetans had an intervention from the French or did not see consistency in outcomes as desirable. French is the name of the author. Noted that they did not see consistency and outcomes as desirable. There was no French influence in Tibet, as far as I know, because they believe every person and matter to be unique and learn more or think differently about law itself. So therefore, it must be important to take an anthropological point of view to remove the common law bias, to see it as some sort of consistency between the people and the processes of creating laws. So by incorporating this anthropological point of view, but also by incorporating law and history within academia, we might be able to, the author hopes, find new discoveries. So moving to section 2, a comparative approach, rewards and pitfalls. So our second suggestion of 3. If legal historians of China grounded themselves in comparative law, it might help keep culturally embedded assumptions about law from creeping into their analyses. Comparative law is where we get useful ideas of sources of law and legal institutions, both more neutral than their corresponding terms, statutes, case law, and constitutions, with respect to the former, and courts with respect to the latter. Madeleine Zelin's frequent contact with comparative law may have helped her develop neutral phrasing, such as security of property rights, the cost of transactions, and the limitations imposed by custom on private agreements that avoid describing King China using constructs of Anglo-American words. The Anglo-American world. So just by taking a comparative legal approach, one can avoid using these Anglo-American terms. Wilfred Elford identified in China a strongly rooted reverence for classical artworks and texts and a long-standing predilection for mimicry in them, and is among the clearest voices advocating for a comparative approach to the study of Chinese law. Karen Turner advanced similar argument, maintaining that research by an outsider into Chinese law is inherently comparative. So that's a strong point that maybe counteracts the whole thesis, in that Karen Turner notes that any work into Chinese law by an outsider is inherently comparative. So maybe there's no need as long as it's done by outsiders. Park-Cassel, as the leading scholar, compares China and Japan in the late 19th century to learn why Japan strengthened more quickly than China in the international stage in the 20th. So by having taken this comparative approach, find how that's affected their development, their parallel developments, or parallel in time, but not parallel in success. The risk of distortions of the West vaunted and the East was demeaned as well. Basically, that was one of the theses, was that Japan sort of glorified the West in some ways, and the East, or China, did not, and such. Thomas Stevens' dichotomy in order and discipline in China, the Shanghai Mied Court from 1911 to 1927, typifies this idealized and likely false approach. This false approach meaning that the West is vaunted and the East demeaned. So in that, it's this author, although Park-Cassel took an important scholarly approach, it tends to have a certain Western bias and an Eastern sort of dislike. And also, Thomas Stevens also manifested this approach as well. Matthew Sommer's masterful research in the Emperor's regulation of sexual practices and prohibitions on the scale of women using the Dian, or the King Code, applies inspiration of Michael Foucault, whose analysis on regimes within prisons and monasteries depicts their limits on sexual practices as power plays. Sounds more like rule by law than rule of law. So by incorporating perhaps the Michael Foucault approach, which is also aligned with critical legal studies, one might find that even though these improvements were made regarding women, they were used to subdue the population, not necessarily to improve women's rights. The other area of research important to China's globalization, particularly in investment leading to governance in parts of Africa and Latin America. So as one might know, China has much significant investments in Africa and Latin America at this present time, and it's important to explore the transplantation of the Tang Code into Korea and Japan as done by Jonathan Spence, John Fairbank, Arthur Whaley, and R. Randall Edwards, and more recently by Alison Connor, Christian Henriot, Frederick Wakeman Jr., and Barack Kushner. According to the author's research, municipal councils were introduced from France into several coastal cities in China in the mid-19th century, so my apologies, there was, in fact, French influence in China. Christian Henriot showed that Municipal Council of Japan of Shanghai promoted the sanitation and urban infrastructure even as it imposed foreign rule upon hundreds of thousands of Chinese. So there's kind of this two-way dynamic, but also falls under comparative research in that how did the French influence China, and how did what were the benefits as well that came, such as improved sanitation. But then how can this be compared comparatively to Africa and Latin America? And my apologies for confusing the term, the author French and French, but there was nonetheless French influence in China. My apologies. There's also must look into China's influence on Europe as well. Namely, it's clear that the Napoleon Civil Code of 1804 famously borrowed its structure and content of some provisions from the late Roman Emperor in Justinian's Corpus Juris Civilis. Yet European diplomats with experience in China today speak of evidence that Napoleon admired the vast bureaucracy. So perhaps France itself has a Chinese influence, specifically in the Napoleonic Code. It is not the centralizing of France's government into his person as emperor. Would he not have looked at the world's oldest code-based legal system still in force? So would it be irrational to believe that Napoleon did not consider China? And parallels found in the Corpus and King Code too, such as the preliminary part, which threatens criminal punishment of judges who refuse judges' cases on the basis that no code provision covered them. The King Code could the King Code not have influenced this part, and rather than the Roman law, or in addition to the Roman Code? So maybe the Roman Code was influenced by the King Code, or maybe they both independently influenced the Napoleonic Code. But nonetheless, there's clearly some influence there. And the rise in the Chinese Communist Party is also evidence of foreigners exercising vast powers over Chinese subjects in the late 19th and early 20th century. And Mao Zedong was well understood reaction and used to win over the public support for the Communist Party against great odds to steer in the position of central ruler in 1949. So there's this argument of it's a response to the outside forces, so another place for comparative studies. So moving to the third component, penetration of law into society. So as we have the chapter on law and law _ society. It's not necessarily law into society as written here. Law and society, society and law, society of law. There's so many. It's really the interaction word is very important. But nonetheless, in here it's penetration of law into society. So piercing the official line, which usually gives the impression that law is self-enforcing and is evenly and equally enforced across the entire territory subject to the law, is of utmost importance if we are to understand the degree to which law penetrated into Chinese society before today's China's Communist Party brought its deep rule into everyday life. So there's the argument here, firstly, that it has to be believed that it has changed over time, but also that perhaps it's stronger now than ever before. As mentioned earlier, the anthropological methods help us to see through official versions of the legal system because they allow us to examine the record closely and from the ordinary person's perspective. The law and society approach, where we dispense with the myth that law operated autonomously from society, should help us with this endeavor. So that's the part of the law society approach, is seeing that law operates autonomously from society, or this, sorry, it must be dispensed with, in that there's inevitably interact. And that's where one of the big questions is, if they inevitably interact, is there any real difference between law and society? Is one of the questions posed in the Law _ Society chapter. There's also a multiplicity of perspectives. For example, Yu Jingzong and Chen Shuyi, who are both mainland scholars, differed in their sights on the 1950s and the 1980s, and that Yu saw continuity in the government's approach, while Dean of Peking's University Law School saw an abrupt face. So the other saw, Chen Shuyi saw an abrupt face. Chen was close to the Chinese Communist Party's story, suggesting the rule of law had taken root in a short span of time and was resurrected, but probably somewhere in between. So there's basically these two different ways of looking at it, and that there was some continuity with the Communist Party, or the other approach, the Communist Party suddenly changed things, and it's probably somewhere in between. There's probably some continuity, there's probably some sudden change as well. Fei Cheng-Kang's work on clan codes reveals a rich vein of statutory codes and courts that for centuries were based entirely within families. Mary Sato's research into religious ritual shows an integral relationship between government courts and their spiritual counterparts, which were overseen by Taoist and Buddhist priests, guilds, and families, and there was these alternatives to law. So by taking this law and society approach, or law into society, we can see how it also interacted with the religions and also communities as well. Therefore, the development of law in China can be seen as a story of law's penetration into society over time, and maybe increasingly so, but probably not exactly linear. It's useful here to approach the subject of historiography by starting with the source of law that was most limited in its reach, the dynastic codes and imperial edicts, such as Da King Lu Li. Its contents make clear it was written not for the general public, but for district magistrates. So something to look at by taking a society approach is that the law seems to be written not for the general public, but for district magistrates. As well, the work of Netzi Bartlett, Brian McKnight, Nancy Park, and Cheng Wei-jen explore how much discretion was at the level of district magistrates. So at that particular time, during the Qing period, but maybe it's obviously changed over time, but nonetheless, these magistrates sort of, although central in that they were tendons of the central government, sort of kind of somewhat autonomous tendons, I suppose. So therefore, how did Dao Tai often translate into prefect? So these prefects in the municipalities, who were circuits of attendants in late imperial China, exercised his or her, well, I think they were all his, at least she uses his here, authority, and to what extent he was bound to the same rules that bound subjects of the locality. Bradley Reed's exhaustive treatment of clerks and runners who carried out commands of district magistrates came to be paid out of magistrates' own salaries, as localities became increasingly adept at organizing their own affairs and fending off intrusion from statutory regime of Beijing. Matthew Salmer, too, shows the change in regulation of sexual mores during the same 2.5 centuries, which shows the increasing aggressive use of national law to control the population. Therefore, shows sort of a steady increase in Beijing, but once again, likely changed over periods. But nonetheless, some of these sexual rights might have also been exertion of power on behalf of the capital. Documents offer significant potential for shedding light on zones of autonomy for central rule. Madeline Zeleng studies property litigation during the Qing period and concludes the rights of property were well defined. Therefore, there was established civil laws, and by focusing on civil, not the political laws. Feng Xiaoting read hundreds of documents pertaining to the sale of buildings in Shanghai in the 19th and 20th centuries, and found evidence of reworking of promises in such documents long after signed and dated. Therefore, they were perhaps weaker, or depending on how far they got from the capital. Care must also be taken not to project American or European conceptions of these private legal tools upon artifacts examined in China. Example, it's hard to prove that a jade tablet carved with boundaries of a tract of land and a price and names of buyer and seller was not simply a memorial of the transaction, like a receipt, rather than a promise to do something that the parties will agree to be enforceable by a third party neutral. So that's something a very important point, not to put these American or European constructs. So maybe just this jade tablet was a receipt but had no legal force. So like it didn't count as a deed or anything like that. It just showed that there was a transaction, but tomorrow it could be smashed and the land taken back by force, for example. Personal connections too, known as guanji, form relationships built on shared interests and foundational trust that obviate the need for contracts. So even if there were non-written contracts, there might be unwritten laws as well, and necessarily only for arm's length transactions. And how important were these over different periods, and probably depended on how strong or weak the central government was. As always, what counts as law must be explored. Mark Ali sets out some examples of what he calls customary law related to land ownership control in Taiwan and Szechuan. Philip Wang endeavored to compare law and custom during the King and Republican eras, and therefore, and also leads to the question, is custom law as well? Even partial or imperfect answers to these questions will illuminate our understanding of the reach of law in China in eras before our own, and the purpose is not to show how sophisticated, but how to reveal how much freedom there was in China to order one's affairs. So, there is this also necessity of looking at custom, comparing custom and law, and deciding is custom law itself, but also the main point of this third suggestion is to look at how law has impacted society over time. So not law and society, as previously mentioned, which should also be meritorious, but how law has gone into and affected society over time. And it seems to be generally increasing over time, but perhaps linearly, perhaps non-linearly, perhaps increasing, decreasing, but ultimately up in the end. But it's all a very, I think, fascinating topic. So, moving to section 4, the conclusion. So, the field of Chinese legal history, the author notes, is buffeted by many of the same headwinds facing other areas of legal history, such as those associated with trends in academia that seek to facilitate the relevance and into a monetizable scholarship, that lead to expert, quick and clear answers, linguistic and logistical challenges that must be surmounted in order to read archival material in Chinese, however, set this field apart and in some ways help explain why the field is still in its infancy. So, not only are these cost factors, but one of the difficulties is that there is a linguistic barrier for most Western scholars, but it could be done independently in China, but it wouldn't have that comparative approach the author alludes to. We can also find, the author notes, another salient characteristic of the field of Chinese legal history by considering the rise of China in the 21st century, and it no longer should be boutique or periphery, but central to the world's concern. Not since AD 700, when law codes of Empress Wu Zetian's Tang dynasty spread to Korea and Japan, and its armies re-established the Silk Road and came within a hair's breadth of Europe, has it been as urgent, the author notes, for the world to understand China's vast experience with the law. So perhaps China is as important in the world today as it was in AD 700 when the Tang dynasty almost conquered Europe or almost invaded Europe, and the great longevity of China's law codes and millennia of its formalized rules for trying disputes and meting out punishments which were prescribed in law put Chinese legal history in a class by itself, deserving of study for its own sake, for the sake of better understanding of a significant piece of human experience with law. So that's one thing to note as well, like if almost a quarter of the population is from China, that at least it's a part of the shared world history as well. And as we've seen, it's influenced perhaps other legal codes too, such as the Napoleonic Code, which inherently also influenced many other civil codes as well. Therefore, continuing to build on the language training and knowledge about Chinese society that has produced many important works, we must extend the legal historian of China's training to include a technical understanding of laws and anthropological tools, so incorporating law and anthropology, such as interviewing and attention to the body of visual cues, and sensitivity to a broad array of moments where law takes effect. Legal historians of China would do well also to become sophisticated about the comparative significance of potential of their work, such as the European legal historian Matthew Dyson defines legal history as the study of the causation in historically and legal relevant events. Proving causation is nearly impossible, but comparative legal history will help us go in this bold direction, a direction that scholars of other places legal histories are going. Happily, there seems to be a trend among the current generation of historians who read imperial-era court cases to develop effective means to probe beyond the official version of law and into the facts of everyday life. So that's the third point, how law is going into society. And may such work, the author notes, continue to enrich our appreciation of the challenges and ingenuity of the Chinese experiences of law. Law, once again, going back to the metaphor, is like the reflection of the moon. It is both indirect and ever-changing. So, very beautiful chapter by Tahirih V. Lee. We will now go and discuss the contents of the chapter here. I hope this was, if maybe you're not a Chinese legal scholar, you hopefully learned a lot about this area of research, especially as it is developing in the West, looking into the East, but also some of the difficulties within the East itself. So, the institution of Tahirih V. Lee is at Florida State University College of Law, where she is an associate professor. Her expertise includes comparative civil procedure and dispute resolution, globalization of law in Asia, law and local autonomy in China, the future of federalism in China, business transactions in Chinese societies, traditions of Chinese family law, international trade and China, Chinese legal culture and sources of law, Chinese legal history, and court system of law. One thing I do note that here is that, as she noted, part of the scholarship is driven by commercial reasons. A lot of her areas of focus are on commercial factors, and perhaps that is because those are the ones that draw the most funding from the university's hypothesis I put forward. But nonetheless, she is still fascinated in it regardless. Her suggested readings are The Application of Law as a Key to Understanding Judicial Independence, published in the 17th Florida International University Law Review, forthcoming in 2022, so it should be out by now, so I hope you check it out. According to her website, is still forthcoming though, but perhaps not updated. I'm sure one can find it. Chinese Law, next publication, Chinese Law, Sociological, Political, Historical, and Economic Perspectives, at the 4-volume anthology published by Garland Press in 1997. So moving to the quotes. An old Chinese saying that evokes a widespread cynicism about even the existence of a rule of law in China. The Chinese law is like the light of the moon. It is different at the beginning of the month than in the middle of the month. In other words, the moon's shape constantly changes. In another way, it is a secondary light illuminating the landscape imperfectly. So very, I think, profound analogy, but even an analogy that was brought by Chinese themselves. Next quote, the development of law in China can be seen as a story of law's penetration into society, and so it is useful here to approach the subject of historiography by starting with the source of law that was most limited in its reach, the dynastic codes and imperial edicts, and then move from there to examine the sources of law that allowed for progressively greater effect on the population. So many things here, where to start, sort of a very directional quote, but also showing that there's this progressivity of the greater effect of law into society on the population. So a trend might not be absolutely linear, but generally upward, or generally increasing, or greater effect. Third and last quote, happily there seemed to be a trend among the current generations of historians who read imperial era court cases to develop effective means to probe beyond the official version of the law and into the effects of law on everyday life. May such work continue to enrich our appreciation of the challenges and ingenuity of Chinese experiences of law. So ends with an optimistic quote as well. So once again, this is the chapter by Tahirih V. Lee in the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. It is in section 4, Traditions Tracing Legal History, and it is chapter 41, By the Light of the Moon, Looking for China's Rich Legal Tradition. And as for the locos, we have Stanford University, where she received her bachelor's and first master's degree, Yale Law School, where she received her Juris Doctor, Yale University, where she received her PhD in history, and Florida State University, where she is currently an associate professor at law. So I will discuss her more in the comparison with Shaunnagh Dorsett after discussing her chapter. So Shaunnagh Dorsett is also in part 4, Traditions Tracing Legal History. It is chapter 42, and it is titled Tracing Legal History, Aboriginal / Indigenous Law, or in brackets, Australia / New Zealand. So to briefly discuss her biography before going into discussing her chapter, Shaunnagh Dorsett is a distinguished professor and associate dean of research at the Faculty of Law at the University of Technology in Sydney, with focus on questions of authority reaching across legal history, jurisprudence, and contemporary Indigenous rights to land. It is an interdisciplinary area of work drawing on legal doctrine, legal history, and history of political thought. She is an honorary fellow of the American Society for Legal History and a member of the board of European Society for Comparative Legal History. So it might be noted a lot of the authors in the Oxford Handbook of Legal History are from the American Society for Legal History, so perhaps many of them met in this way. She has a Bachelor of Arts and a Bachelor of Law, the honors from the University of Tasmania, a Master of Law from the University of Calgary in Canada, a PhD from the University of New South Wales. Her publications include Juridical Encounters, Maori and Colonial Courts from 1840 to 1852, published by the Auckland University Press in 2017, and as well Property Law in New South Wales, published by LexisNexis in Australia in 2017, and Jurisdiction, published with McVeigh S., published by Routledge in 2012. So once again, her chapter is in chapter 41 of the Oxford Handbook of Legal History, edited by Marcus Dubber and Christopher Tomlins. It is in part 4, Traditions Tracing Legal History, and it is chapter 42, titled Traditions Tracing Legal History, Aboriginal / Indigenous Law, open bracket, Australia / New Zealand, close bracket. So starting with the introduction. The stories of the encounters between Indigenous peoples in both Australia and New Zealand and the British Empire have been told many times and from many perspectives, the author notes. They are still being told, and stories of legal encounters and of legal relations between Indigenous peoples, the Empire, the succeeding nation-states, and those who arrived under the auspices have also been told. Like more general histories, consideration of the history of legal relations has been wrapped with the history of dispossession, and now often tied to questions of legal consequences under the current law. Land, the taking of it, and the result have become central to think about how these relations and how we think about history of these relations. It intends to obscure the fact that it was not just land taken, but the Indigenous laws themselves. Tikangi Maori, for example, in Aotearoa / New Zealand, struggled to survive the onslaught of settler law, and even now are dismissed by many as not law. So I think this is a very profound way of looking at it, and that although it's important to note all the land that was taken, there was other things taken as well, such as law. So it wasn't just the physical things that were taken, but the law itself. There are obvious commonalities, she notes, between the colonies, such as they share a common legal heritage and traditions, and they are subjection to the rapid settlement and governance by Christianization, civilization, military and settler violence, and criminal law. So there are these commonalities. Forces, however, played out differently in different colonies and resulted in different histories. Comparative or transnational accounts are rare. Damon Ward, for example, The Politics of Jurisdiction, British Law, Indigenous Indigenous Peoples and Colonial Government in South Australia and New Zealand, which was his doctoral thesis at Oxford in 2003, is a notable exception, and in some ways starts from different ways the British authorities regarded Indigenous Australians and Maori. So one place to start, as this author did, is how the British viewed these different Indigenous communities in Australia and New Zealand. One considered the low on the scale of civilization and had little discernible by the way of law, had a relationship with the land that the British did not understand, and offered little in the way of trade. The other had a more recognizable attachment to the land, and they had norms that the British recognized as laws, albeit considered less civilized, and had goods to trade and labor that was vital to the survival of the colony. This had different beginnings, grew into different legal processes and institutions, and a way that Indigenous Australians and Maori differently came in relation with the national laws of these states. So it's very important to note here that taking this approach of how did the British view these different communities significantly affected how the ultimate outcome, in that the British viewed perhaps the Australian Indigenous people as less sophisticated, having little land rights and such, and on the other hand saw more prominent laws in New Zealand and stronger land claims. There's an ongoing dispute in British Columbia, my province, in that Captain Cook, who is one of the debatably greatest explorers, I personally do like him, but obviously his history is in some ways is guilty of some crimes as well, but as well I think he's still a great explorer. But nonetheless, when he went to the British Columbia, or the coast, he noted that the peoples there, and he wrote in his diary, which one can read, and it's very fascinating, they had the stronger land claims, he noted, than some other, perhaps more nomadic people. So this has had large repercussions on if the land claims are stronger, then they have evidently stronger claims than some might in the east. So that's something to note about, maybe in Captain Cook's defense, although he ultimately died in the Hawaiian Islands against the Indigenous peoples there. He didn't just have one brush stroke for all Indigenous people. He actually saw them as nuanced people, which I think is a step not in a step away from racism. I think racism starts by grouping people. So to put all Indigenous people in one group would be the most racist thing, but still, nonetheless, maybe some of the things he did were not optimal, but nonetheless, I think it's a very exciting case. But that's also going back to how the British viewed Indigenous people in New Zealand and Australia, or the reverse, in different ways. Nonetheless, showed at least they had a nuanced appreciation for the two. And therefore, to what extent does the process of looking for commonalities flatten history? Is there a gain in looking at continuities and divergences enough to warrant this exercise? What might be lost in doing so? And matters will be returned to in the conclusion. This chapter, however, will look increasingly at the maligned but often used source of historical material, court decisions. So this will actually focus more on court decisions, and we'll discuss a few, and in order to suggest two contact points between jurisdictions through which to think about Indigenous laws and settler laws, and pays attention to only two rather conventional times of contact, colonial and present. So we'll only be looking at colonial to present time, but there's also a long history before that needs exploration. In many ways, this choice reproduces the ongoing gaps in tracing and thinking about legal encounters with Aboriginal law in Australia and to a lesser extent New Zealand. So things are still, as you note, not as bad in New Zealand. and scholarship on legal encounters centered on colonial period have been the detriment of the later 19th and 20th centuries. Finally, it should be emphasized that this chapter looks at ways in which colonial and modern law engages with Aboriginal law from the perspective of the colonizer, not the colonized. The traditions are those of Western law, not the first peoples of either nation. So, nonetheless, we're still looking at the laws of these two Indigenous communities through the lens of the West. So, moving to section 2, after the conclusion, dispossession and displacement, immediate context and obvious differences. So the author notes there has been little work on legal encounter which crossed all Australian colonies. The obvious reasons for this is common to almost any endeavor to think comparatively or transnationally with law and or history, and do not need recitation. It's simply to point to the problems of assessing the materials, the difficulty for non-New Zealanders of understanding Maori concepts of language which pervade the primary and secondary sources, and relatively small cadre of scholars in both Australia and New Zealand when compared to North America, for example. Recent digital innovations, such as the provision of colonial newspapers online in Australia titled Trove, and in New Zealand Papers Past, have played a role in making this material more available to scholars. So multiple forces. Firstly, that many people aren't able to read them. Secondly, there are fewer of them, fewer as compared to those in North America. And thirdly, until recently, they were not available to the public. Before looking at both points of contact between jurisdictions, this chapter chosen for this chapter, which are Australia and New Zealand, context must be required. Much of the thinking about Indigenous Australians and their laws comes from deep history of denial of legally recognizable relationships between Indigenous Australians and their country, and the denial that Indigenous Australians had laws recognizable as such. In 1788, Indigenous Australians had lived on the continent and surrounding islands for over 50,000 years and were self-governing peoples with complex laws relating to all facets of life, from family and land, life and law. Tribes and clans entered into agreements with each other to govern boundaries, trade, and rituals. Diversities and similarities forged shared and diverging interests to the country, to the dreamtime, art, and ritual. Little visible or understanding to the British and others who followed in their wake. So by the time they got there, there was it was so alien and unrecognizable, the author notes. W.E.H. Stanner famously referred to this as cultural forgetfulness, so a lot of this has been forgotten right now. By the 1840s, at the time of New Zealand's formal settlement, the idea that Aboriginal Australians had neither law nor rights to land were dying out and doomed for extinction had taken hold. So they thought even those who thought that the laws exist saw them as dying and not worth researching, which is evidently wrong and very unfortunate. To put a complex early history in a few sentences is impossible, but the attempt here is that the 19th century early ideas of plurality had been forgotten, while wide-scale dispossession in many parts of Australia had drastic effects on Australian peoples, their lands, and their culture. This was different for New Zealand, however, which was annexed some 50 years after New South Wales, and the timing was crucial. And this distinct reluctance to take sovereignty over New Zealand meant that by the time the British determined to do this, different policies, different intellectual views, and different understandings of Indigenous peoples and their place in the empire held sway. So the New Zealand was colonized some 50 years later, and this had significant repercussions. And if we were to make one ultimate cause, this time difference maybe itself was the cause. So maybe it would be wrongly to assume that the Indigenous people of New Zealand had superior laws or superior sophistication, but rather by the time the British had come to New Zealand to colonize it, they had more moderate views, or perhaps more respect by that time. The status of Maori law in the 1840s is still subject to some debate. clear views quite differently for the same matters in Australian colonies. They understood the assertion of sovereignty over islands of New Zealand hardly meant common law and had become legitimate or even effective law of the land. So by the 1840s they did sort of respect this existing Maori law, whereas by that time Australia had unfortunately, the Australian Indigenous peoples had already had suffered significantly. They recognized Maori were sovereign and had, albeit a brutal or uncivilized, laws of their own. Article 3 of the Treaty of Waitangi declared Maori as subjects, but not to British law in all circumstances. So, an exceptions there, particularly not in respect to many intra-Maori matters, and this was governed by Tikanga Maori, which means Maori law, and some laws were not enforceable too. Nonetheless, land transfer to Crown took place, called Rapatu, which kind of Rapatu, which means confiscation. And then under the Native Lands Act, customary title transformed into freely alienable simple title. And by the end of the 19th century, little customary land remained, but not none, important to note. But purchase, confiscation, and conversion are, however, one explanation for why New Zealand has not experienced the phenomenon of common law claims to native land or Aboriginal title, which have been so prominent in Australia and Canada for the late 20th century. So there was perhaps a different process of land transfer here that have led to fewer now common lawsuits. These processes meant extremely difficult for Maori to fit within the confines of the doctrines of the Aboriginal or native title, with emphasis on continuity and uninterrupted connection. This caused a plethora of institutions, such as the Land Commission's Native Land Court, to modern Waitangi Tribunal, and not have all had positive outcomes, must be noted. However, there are different processes that, as we might see in Canada, Australia, or the United States as well. By the late 1960s, both jurisdictions and broader Anglophone world, the Indigenous activists began to agitate for redress for the loss of land and justice for devastating imperial and colonial practices, and it culminated in two quite different judicial processes. In New Zealand, the Waitangi Tribunal, which is a permanent commission of inquiry tasked with making recommendations to the Crown based on acts of omissions relating to breaches of the principles of the treaty. As a result, it has taken a number of inquiries into historical claims. In Australia, however, by contrast, questions of redress have left to the regular courts to determine the common law according to the doctrines of native title. So important to note here, in terms of addressing these issues, in Australia it's put to the Australian courts, whereas in New Zealand they have the Waitangi Tribunal. Many other points of comparison can be noted, such as New Zealand's modern treaty process, statutory land rights regimes in Australia, redress for stolen generations. The list is long, she notes, but nonetheless, on almost every point, there's a difference in New Zealand and Australia, while being not even that far. What has, however, received comparatively less attention is the legal relations of Indigenous law and Tikanga Maori law. Outside issues of redress for land to national policy in general and the common law in particular. So, although there have been differences in such as these land transfers, there hasn't been much study in the differences between Indigenous Australian and Tikanga Maori law. So, let's say the land was taken or they were colonized at the same time. What are the fundamental difference between Maori and Indigenous law? So those are neglected areas, perhaps because in Australia it's more lost. The physical dispossession was more obvious to those who chose to look than was the loss of law. In Australia, after all, required some initial assumption that Aboriginal peoples had recognizable laws that should be recognized, respected, and enforced at all. In New Zealand, they accepted that Maori retained some law, but questions to the extent it was recognized and whether it should be recognized as such in the modern era is still being addressed. Institutional emphasis on dispossession of land and the histories of dispossession by force and the law outstripped histories which seek to understand more broadly how common law met Indigenous law and how this might impact how we understand the relations between the two in the modern era. So this even can come down to how the two countries interact today. Moreover, with the exception of the work of Damon Ward and Lisa Ford, what histories have emerged remained tied to particular jurisdictions. So there has been this neglect of this comparative approach, which the author is manifesting here, and which clearly lead to new findings. And there are lack of sources as well, small cadre of scholars engaged in this activity, and the need to find points of entry into comparisons and contrasts have all also contributed. So moving to section 3, legal encounters, traditions and techniques, common law jurisdiction. So where are the points of comparison? The author questions. Where should we direct our attention? The work over the recent decades in both Australia and New Zealand on colonial legal encounters has centered on questions of sovereignty and jurisdiction over the indigenous inhabitants of Australasian colonies, and largely confined to single colonies. But Damon Ward, as previously mentioned, work shows working through the lens of jurisdiction can be productive in drawing out commonalities between colonies and their approaches. It draws on common inherited legal traditions, and the emphasis on legal technique rather than substance can illuminate similar issues across time and place. Rather than focusing on divergences, for example, existence or not of a treaty, look for technologies and techniques of common law. So look at the process of jurisdiction, so a different lens to look at this, and rather say, oh, this has a treaty, this doesn't have a treaty, therefore different. Look at the technologies and techniques of these two processes. In Australia, investigations of common law jurisdiction and amenability of Indigenous Australians to settler law owe much to the work of Bruce Kircher and the Colonial Case Recovery Project in the beginnings of 1990s. This discovery of early decisions of New South Wales Supreme Court disrupted dominant narrative of early colonial period legally characterized by blanket refusal to consider that Indigenous Australians had laws. This was a breach of narrative, was not strong, and did not lead to any rethinking of these matters of the modern period. But it's important to note that it was seen as a discovery, as though it had been lost between. And the work began to spread to include other colonies such as South Australia and Western Australia. So taking this comparative approach, but at least only within Australia itself. Ford's examination of jurisdiction and the formation of settler sovereignty of New South Wales and Georgia stand out, as does Damon Ward's examination of constructing jurisdiction over Indigenous people in South Australia and New Zealand. In New Zealand, similar case recovery efforts also led to new historical inquiries and understanding of legal relations between British law and Tikanga Maori have been of interest for much longer. Despite this, the work of similar nature to that in Australia still did not appear until the 2000s. So it's still, even though this work is being done in Australia, it has lagged behind the work in New Zealand, despite the history of Australia being and the history of the British contact with Australians being 50 years longer. While in the 1970s, scholars such as Alan Ward produced detailed accounts of British policy and laws as applied to Maori, questions as to exactly how that law was revived have remained a live issue. And it's important not to exaggerate this, but it remains a domain with a small number of scholars. So there are these notable exceptions, but it's still this comparative law, as the author is really pushing for, it needs greater attention. The author notes we are comfortable with modern law with using cases as precedent, but less comfortable with examining them as relics and reminders of legal technique and as historical rather than strictly legal sources. So taking a legal approach to these. In late 1990s and 2000s, respectively, new cases emerged in both Australia and New Zealand which shone light on early attempts to argue that common law did not apply to relevant Indigenous defendants. And the same question was asked, did common law have jurisdiction over the defendant, whether the matter was inter se, which is within itself, where it did not involve persons or property of a settler. In 1829, so these are some very exciting and important cases that we're going to delve into now, which is titled R v. Ballard, Regis v. Ballard, King Queen versus Ballard. Forbes CJ was faced with the questions of amenability of Aborigine to the common law for the murder of Borrow Deer, or Dirty Dick, near Sydney. Albeit the law was shocking to the notions of humanity and justice, nonetheless Aborigines make laws for themselves and are preserved and violate and are rapidly acted upon. And the British did not intervene on this, so it was completely, this is in the Australian context, there was an issue of murder within the Indigenous community, and they noted firstly that there was a law that existed within the Aboriginal law that could cover it, so therefore the British did not intervene. And this was 1829. Almost 20 years later, in New Zealand, the Supreme Court, faced with questions of its own jurisdiction for the murder of Kopareem by Ranjit Tahirih, and what asked, did the court have jurisdiction? And it had a slightly different answer, but it said yes, said the court, but not over all matters inter se, just with respect to those which were unacceptable as against the laws of humanity. So here, and murder was such a one. And they found the scale of civilization of Maori was different from Australia, and nonetheless the underlying common law technique in Australia had drastic effects on the Aboriginal peoples, their lands, and their culture. And both Ballard and Rajitapuri were lost from view, however. As precedent, the decision of Ballard lasted less than 7 years, so that the Australian one, although they gave jurisdiction to the Indigenous peoples, it lasted 7 years, and then they said, oh no, the British ought to control this matter. And in Rajitapuri, where even here it was more limited, they said that the Indigenous peoples could govern themselves on certain inter se matters, but not those such as murder, which is something, crime against humanity, they called it. That was in 1836, the same court changed its mind, declaring jurisdiction. Sorry, going back to Ballard. So Ballard, 7 years later, the court in 1836 changed its mind and declaring jurisdiction over all Indigenous matters inter se. And effectively no Indigenous law was recognized as such in Australia. And as for the Rajitapuri, was also lost. However, it was not overturned, rather was part of a general forgetting or better refusal of the time when Te Kangi Maori was taken seriously as law. So although Rajitapuri noted that there were some matters inter se where Maori law might come into effect, it was sort of forgotten and it was hardly ever used or applied. A new case in 2012, quite recently, regarding a Te Kangi Maori to determine the place of burial. After Mr. Takamore's death, his family took his body and buried it without the consent of the executrix, Miss Clark. In the family was called, they took it to Urapa, a burial ground in accordance with Tuho custom. Miss Clark, however, wished to bury the body in Christchurch, Takamore's body in Christchurch. So both the Court of Appeal and Supreme Court attempted to articulate ways in which the relevant Tuho custom could be given some value or force within common law. So was there some reason why the Tuho law gave them the right to take this body over the common law right of the executrix? The Court of Appeal attempted applying a traditional criteria of recognition since time immemorial, reasonableness, certainty, continuity, and non-extinguishment, but the court determined it could not, and New Zealand court unanimously determined that Mr. Takamore's body should be returned to the executrix for reburial at the place of her choosing. So they They attempted, and they gave many different ways that they could be given to Tuho law. Maybe Tuho law get supremacy over the common law, but they couldn't. So the executrix took the body back to Christchurch. Two minority judgments disagreed as to whether the executor ruler was part of the law of New Zealand, and hence the primacy of the rights to be accorded to the personal representation, but all members agreed that determining how a person was to be buried to Kinga was relevant for consideration, although it differed considerably as to how relevant the consideration be taken. So they did look at the Tangi Maori law and said perhaps it does have some influence on how the body should be buried, but it cannot be taken exclusively, or at least in this case could not overcome the common laws of executrixes. And this was cautiously welcomed, and what was law was now custom, it was noted. It was remembered that the substance, not the technique, should be looked at, and the understanding of how these matters were considered at the outset of the colony and how they might be understood now can help to refute the idea that Takanga has no force or validity. So by taking a historical approach, maybe we could find some cases that might justify this, and might even have potentially some of these cases overturned, but nonetheless there's little precedent or little successes on the account of Maori law over common law. Moving to part 4, institutions and cases, displacing laws. So a second way of thinking of cases as historical materials which can help us trace Indigenous laws and their encounters with settler law is through investigations of colonial curial institutions. English courts, sometimes by way of other places in Europe, arrived in both Australia and New Zealand to be transplanted and domesticated in new environs. We know little of how Aboriginal Australians or Maori interacted with these new settler courts. While cases like Ballard and Ranjapiri can tell us much about matters such as shape and sovereignty of the legal techniques of the encounter, they can tell us almost nothing about the coalition interactions of Indigenous peoples with settler law. Much occurred in lower courts, which rarely receive any scholarly attention, and this is a fertile site for encounters in both Australia and New Zealand. So although these cases, as mentioned, are very important, Ballard and Ranjapiri, they are superior courts, or they've made it to high appellate courts, and they neglect where most interactions take place, which is at the local courts, and at earliest courts as well. In both Australian and Aotearoa / New Zealand, one site of engagement for Indigenous peoples with settler law was with new courts of the colonizers. In all jurisdictions, magistrates' courts, staffed primarily by laypersons, often ex-military, dispense justice in both towns and remote parts of the colonies. So often these courts were staffed with military persons without legal backgrounds. From King George Sound in Western Australia to Nelson in New Zealand, so from west to east in this area, magistrates adjudicated not just criminal matters, the traditional fare of English magistrate courts, but increasingly, as the 19th century wore on, in civil matters. So these courts were sort of maybe even overstepping this place in common law by not just trying criminal matters, but also civil matters as well. Usually there was no precedential value, and only state who went to court. And so in terms of these records, it usually doesn't state too much details, just that who went to court and the brief outcomes, and very little reasoning. What is interesting is that they went to court at all, and likely for different reasons, but nonetheless so. The ones that even are found, what about the people who did not go to court? They probably lost for that reason. So they maybe were the ones that were even closer to success, but still often failures. In New South Wales and South Australia, Aboriginal engagement with lower courts was far more likely to be through involuntary subjection to the law, in particular with criminal law. Amanda Nettlebeck shows it may be a form of exerting colonial governments, and materials also show in some cases, courts superior and inferior were hesitant to take jurisdiction and made way for customary law, particularly with intra-Indigenous violence. So on one hand, sometimes when they're brought to court, it is seen as exerting colonial power, but on the other hand, there were cases where they probably avoided stepping in because through fear of getting involved and through fear of violence, particularly in intra-Indigenous violence cases. In the context of Aotearoa in New Zealand, we know that Maori were active users of both the criminal and civil jurisdictions of both the new resident magistrate courts, and undoubtedly were subjected to the law, in particular the criminal law, and data shows that from the outset the colony of Maori also laid criminal information both against settlers and each other. As the first decade of colonization wore on, they aided the creation of the resident magistrate court and increasingly sued settlers and on occasion each other for unpaid wages, for debts, for unpaid goods, for trespasses on cultivations, and a raft of miscellaneous civil matters. So it's important to note in the New Zealand context, these courts were sometimes used to the advantage of the indigenous peoples, for example by suing the colonizers and also suing each other as well, so they actually sometimes made effective use of them. In 2013, Tamata Mason, charged with 1 count of murder and 1 of attempted murder, was tried. The question was, should it be tried by a Tikanga Maori court? And they found the equivalent law did exist, but the Crimes Act extinguished it. And further, there was no clear place or form to try it. So even if they did accept it and went beyond the Crimes Act, there was no specific place. So those places may still exist, but from the perspective of the common law, they are difficult to discern. So there's not like a specific courtroom to go to. Where would it be done? Perhaps in some traditional lodging or something, or traditional meeting place. But these things would have to be discussed too, which would create complications. So moving to section 5, the conclusion. So what are the prospects for histories and thinking in the future about the past in these two places? As noted, despite the push towards comparative and latterly transnational history in the context of Indigenous peoples and their laws in Australia and Aotearoa, New Zealand, has remained remarkably vacant. This raises the questions about to what extent we might want to try to think more about law and history in these two places in a comparative or transnational way, and what might be gained by doing so. It's now almost axiomatic that as historians take not just comparative but transnational approach, once a creature in the margins, transnational is now mainstream. There are still costs and difficulties of genuinely transnational or even multi-jurisdictional work. So once again noting that the cost difficulties of transnational or international, transnational or comparative work, and where these may be overcome will yield a greater than the sum of the parts. So by looking at New Zealand and Australia, would probably yield more than just doing them independently. Common theme in mergers and acquisitions, economic synergies, one might call them. Findings not available through independence, and these findings by findings that might not otherwise be available in their independence, and the fruit may be found in commonalities that derive from imperial laws, so for example statutes, status of colonies, inherited laws, for example English land law, and common intellectual frameworks such as protective governance. Much still needs to be done to trace how these played out in different locations and the continuities and disruptions, but little doubt that it is an easier task to undertake if one compares an earlier period rather than the later. So as we'll see in the comparison, it's perhaps easier, the author Shaunnagh Dorsett notes, to look at earlier periods rather than later, but as we discussed in Chinese legal history, it's perhaps easier to look at the king because it culminates previous periods, but nonetheless we'll talk about that in the comparison. But by looking at earlier periods, it's easier in this context, she notes. As colonies progress, ways of engaging with settler law and emerging nation state diverge. So if you look at Australia and New Zealand right at their inceptions. They were more similar, but as they move throughout time, their paths diverge. Here, the inherent difficulties attendant with doing comparative and transnational histories are more obvious. One way might be to compare, might be to look at the legal traditions and techniques. Another might be to examine how history is used by the courts and those such as the Waitangi Tribunal in these contexts. All draw on similar historical materials, although the weight given may differ based on the country. Colonial office policy, official dispatches, formal instructions, historical legislation, letters, diaries, and newspapers are all now routinely drawn upon, so expanding the sources of law, as we've seen in archival legal history previously covered, and not just as they always have been done by the Academy, but also by the courts and the tribunals. So these courts and tribunals should also take this more historical approach. Perhaps most importantly, however, is emphasis now given on oral histories as evidence of coeval with documentary sources. So that's very key because many of these communities relied solely on oral communication. The approach taken in this chapter is to try to use one type of material, the traditional case, as we've discussed a few cases here, as a general source through which to think about the relations of Indigenous to modern law in two countries is one example of the work we might do. So also by looking at two countries in cases, it's just one. You could do 3 countries, 4 countries, 10 countries, or one country but different communities. Such approach will not point to the way to a means through which we might structure the encounter of Indigenous and national law in the 20th century. However, an understanding of what these legal relations may have looked like historically reminds us that in both countries, Indigenous laws live on the interstices of the new legal system and the new institutions. The challenge is to uncover the historical materials that will help us locate these interstices and provide a richer picture not just of displacement of law, but of its survival. So, very beautiful chapter. I think it's also brilliantly written in the way she structured it in a comparison between two. And also, like I always think, that's why all my lectures so far or most of them have been focused on parallelism to probably learn more about the sum of the parts in the style of Plutarch, who discovered this over 1,000 years ago. Well over 1,000 years ago. So, without further ado, we will discuss the context of the slide, or the contents of the slide, and then discuss a comparison between Tahirih v. Lee and Shaunnagh Dorsett to learn more through the sum of parts. So, the institution of Shaunnagh Dorsett she's at the University of Technology, Sydney, Faculty of Law. Her positions include Associate Dean of Research and Distinguished Professor. Her disciplines include Law and Society and Socio-Legal Research, Civil Procedure, Law and Humanities, Property Law excluding intellectual property, Global and World History, Australian History, Legal Institutions including courts and justice systems. The logos we have University of Tasmania, where she received her Bachelor of Arts and a Bachelor of Laws honors. University of Calgary, where she received her Master of Laws. University of New South Wales, where she received her PhD, and the University of Technology, Sydney, Faculty of Law, where she's currently Associate Dean of Research and Distinguished Professor. Suggested readings include Juridical Encounters, Maori and the Colonial Courts, 1849 to 1852, published by the Auckland University Press in 2017, and Jurisdiction, written with McVie, published by Routledge in 2012. Her chapter is in the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tollins. It is in Part 4, Traditions Tracing Legal History. It is Chapter 42, Traditions Tracing Legal History, Aboriginal Indigenous Law in Australia/New Zealand. As for the quotes, we have 3 here as well. First quote, I'm going to close the lines quickly, my apologies. Got it. Okay. Despite the push towards comparative and latterly transnational history in the context of Indigenous laws and their laws in Australia and Victoria, New Zealand, this field has remained remarkably vacant. This raises the questions about to what extent we might want to try to think more about law and history in these two places in a comparative or transnational way, and what might be gained or lost by doing so. Next quote, 203. It is now almost axiomatic that as historians we should be undertaking not just comparative but transnational work. Once a creature of the margins, transnational history is now mainstream. Historians, however, know the costs and difficulties of doing genuinely transnational or even multi-jurisdictional work. Third and last quote. Different legal frameworks emerged, and so did different mechanisms through which the laws of Indigenous peoples came into relations with those of the relevant colony or nation-state. Here, the inherent difficulties attendant with doing comparative or transnational histories become more obvious. So I think a very, very fascinating chapter written by Shaunnagh Dorsett. Traditions Tracing Legal History, Aboriginal/Indigenous Law in Australia and New Zealand. So we'll discuss a little bit more about both of these two authors in this comparison in the style of Plutarch's Lives and also in the style of Shaunnagh Dorsett, who noted that through the sum of parts we might learn more about these two. So starting with Tahirih V. Lee, because our chapter comes earlier, so she is an associate professor at Florida State University College of Law, whereas Shaunnagh Dorsett is a distinguished professor and associate dean of research at the Faculty of Law at the University of Technology, Sydney. So at this point, Shaunnagh Dorsett does have a higher position in her respective university, but I believe Tahirih V. Lee has started her academic career after Shaunnagh Dorsett, so there's not to say that she will become the dean of research or dean of the university itself, for that matter, even. But it also must be noted that they're also in two different countries, and that one is in Sydney, Australia, that being Shaunnagh Dorsett, and Tahirih V. Lee is in Florida, in the United States. So they're two different countries, but they're both sort of formerly British colonies. In terms of their degrees, Tahirih V. Lee has a Bachelor's of History from Stanford, a Master's in East Asian Studies from Stanford, a Master's in Arts in History at Yale, a Master of Philosophy in History at Yale, a Juris Doctor from Yale, and a PhD at Yale, whereas Shaunnagh Dorsett has a Bachelor of Arts and a Bachelor of Law with honors from the University of Tasmania, a Master of Law from the University of Calgary, and a PhD from the University of New South Wales. So both of them do have PhDs. They do differ in that one is from Yale University in the United States, and the University of New South Wales is in New South Wales. Whereas also it might be noted that Shaunnagh Dorsett has done a Master of Laws in the University of Calgary, so she has come to North America, whereas Tahirih V. Lee, all of her studies have remained in the United States. That doesn't mean that the United States doesn't have an open mind outlook anyways, but nonetheless, Shaunnagh Dorsett has traveled around perhaps a little bit more through her academic career. There's also differences in their law degrees. In the University of Tasmania, you can do a Bachelor of Laws, whereas in North America, one must do a Juris Doctor, so that's a graduate degree in itself. But Shaunnagh Dorsett does have a Master of Laws, so they both have, I would say, just different ways of studying law. In terms of writings, Tahirih V. Lee has one book and a 4-volume anthology, so much significant writing as well. They both have countless articles as well, where Shaunnagh Dorsett has 2 books. So they're both, I'd say, pretty close in terms of the amount that they've written. But I guess a 4-volume anthology is slightly longer, but maybe they're 4 very small volumes, and they're maybe 2 very large books. So I think they're, whereas many have differed in the amount of writing outputs, they're pretty, I would say, pretty close. And considering that maybe they've had different lengths of academic careers, it's surprising that they're, or maybe not surprising, but it's important to note that they're pretty close in this area. In terms of their areas of research, Tahirih V. Lee is focused on Chinese law, comparative law, and transnational law, whereas Shaunnagh Dorsett is also focused on Indigenous law, comparative, or not also, she's focused on Indigenous law, but also comparative law and transnational law, so they're both similar here. In their two works, they both noted that this is not maybe a difference of them, but something that they both noted that I noted is something different, is that in Chinese legal history, it's easiest to look at the Qing period because it's a culmination of the previous periods, whereas Shaunnagh Dorsett noted in Indigenous law, it's easiest to look at the earliest periods because there's less time for these trajectories to differ. So it's a little difference there. Similarity, they both have a significant influence on interest in legal history. They have both delved into some commercial law or trade law. I think that is maybe, as Tahirih V. Lee noted, maybe it's through the economics of the law schools or academic communities they need to do that, or maybe they both happen to be fascinated in commercial law or trade law. And I don't think the trade is mutually exclusive from international law or anything of that sort, or Chinese law or Indigenous law as well. They both, one thing Tahirih's law's work, it was very focused on, and is probably characteristic of all Chinese law as generally, but it's focused really on the periphery and the metropolis. These are terms I learned from scholar Michael Doyle from Columbia University. So essentially it's how is the capital influencing the people. We saw these runners bringing Chinese law across the country and such as that, and also how has law gone into society, so kind of the dynamic between the metropolis, which is the center, the capital, and the periphery, which is those outside. And technically, in the empire terms of Michael Doyle, what he means is the periphery are the states, subordinate states, but it could be within a city-state, it could be seen on a micro level as well, or within a state. Whereas Shaunnagh Dorsett's style was to focus on two distinct regions, Australia and New Zealand, two different countries, and discover how they had different interactions between the indigenous peoples and colonizers. So different approaches here. Shaunnagh Dorsett's is almost similar to Plutarch's Lives, which I admire, but Tahirih V. Lee's is in the style of Michael Doyle, who I also very much admire. So very different ways of approaching them. And I think another similarity is, as far as I know, I do not think Tahirih V. Lee is Chinese, and I do not think Shaunnagh Dorsett is Indigenous. Maybe they both have, maybe Tahirih V. Lee has some Chinese blood, or maybe Shaunnagh Dorsett has some Indigenous blood, but nonetheless, I don't think that takes away anything from their scholarship. And as Tahirih V. Lee noted, perhaps as an outsider, it inherently becomes a comparative process, so maybe that's even better. I often note that one of the greatest humans of all time, I believe, is Abraham Lincoln, is that because although he did free the slaves, he did not have personal incentive to do it, in that he himself was not subjected to slavery, so he kind of circumvented his, or he came from an outsider and did something good for someone else. So I think that's fascinating that Tahirih V. Lee and Shaunnagh Dorsett are both so passionate about Chinese and Indigenous legal history, respectively, despite not necessarily being Chinese or Indigenous. It's possible that they are, so my apologies if they are. So I think that's two very fascinating chapters on Chinese law and Indigenous or Aboriginal law by Tahirih V. Lee from the Oxford Handbook of Legal History, edited by Marcus D. Dubber. Thank you very much for watching this. I'm very grateful for your support, and I hope you continue to do so, and I hope you continue to follow. So thank you so much.